Where do you expect to start today, Ms. Kaplan?
We're starting with Sergeant Corbett, Part 3, to start introducing the wire.
I'm sorry.
Sergeant Corbett will be recalled to start laying the foundation for the wire.
We're going to be dealing with the wiretap this morning.
Yes, sir.
Okay.
Your Honor, good morning. If the government happens to have a presentation for Sergeant Corbett, we haven't received it.
I don't have a presentation, Judge.
Thank you. All right, so let's go through the wiretaps. Does the state still intend to present the A through SS that was presented Friday?
Yes, sir.
All right, we'll go through each of those. I'm going to group these a little bit so we can move this along.
May I lay out a general objection first?
If it's real brief.
Real brief. With respect to the transcripts, I know that the state, or they've advised me that they're not seeking to have it go back to the jury, so they're staying consistent with the case law. These transcripts were given to us on Friday. They were not shown to us before that. They were not on the table when we were reviewing things. I see from the transcripts themselves that they were produced in early August. The state knew at that time that they would be using these transcripts, should have given it to us then. With respect to accuracy, there is no ability for us to be able to determine the accuracy, because frankly, we can't go over all of it in 48 hours.
Captain?
If they say so, Judge, I mean, I sent them to be discovered as soon as I received them, so.
What do you mean you sent them to be discovered?
I don't know. They're saying they didn't get anything, so I don't know what to do about that. I invited them to come look at everything, and they didn't take me up on it, and now they're telling me they didn't get anything, and I don't know what to tell you other than.
But what documentation do you have that they were sent to them?
I would have to consult my support staff to find out if they have any emails to show that they sent them, but all I show is in my system and listed as discovery. So I think they're demonstrative aids, they're transcripts of calls that have been known to the defense since the inception of the case.
The whole point about transcripts is whether they have some objection to the accuracy of them. I mean, how are they supposed to have decided whether they're accurate without seeing them?
Well, there are some inaccuracies in the transcripts that I noted. I mean, in general, they're accurate, but I think that's why we give the instruction for the jury to rely on the evidence itself, that the transcript is just designed as an aid.
When did you get them, Mr. DeCoste?
When the court did on Friday, Your Honor.
Well, I had time to review them, so I guess you did too. We'll start with A, B, and C. There's 3 conversations, and I'm just going to go in chronological order on these. April 19th. What's the state's theory of admissibility as to A, B, and C? Miss Adelson to Charlie Adelson and back and forth.
That they are not hearsay, they're not being offered to prove the truth of the matter asserted, but rather being offered to show what Mrs. Adelson does when she gets the information, has the contact with the undercover, and the effect on her as the listener, and then on Charlie as the listener.
Are you done?
Yes, sir.
Okay.
Yeah, I thought maybe you'd have a question.
I assume both defendants object to them as hearsay.
Correct. Yes, Your Honor. The state
I'll sustain the objection. A, B, and C will be sustain the objection. It's hearsay. And an academic perhaps only of academic interest, but I think of significance to the state of law in the state of Florida. I am sustaining the objection because law in the state of Florida at this point says so. Frankly, I think the law on conspiracy, admission of statement, hearsay statements in the state of Florida is outdated. They all go back to a 1949 U.S. Supreme Court case, Krulwich v. U.S., 336 U.S. 440, that's Krulewitch, that says conspiracy ended at the time the conspiracy is ended. Frankly, Krulwich does not appear to be followed by any circuit courts, federal circuit courts in the United States that I can find at this point in time. I haven't done a totally exhaustive research, but Krulwich predates the federal rules of evidence. It applied a common law definition of conspiracy, which requires that the statements be in furtherance of the conspiracy charged in the indictment. That's no longer followed by any of the federal circuits based upon federal rules of evidence. Does not require that. Florida rules of evidence are almost identical to the federal rules of evidence. However, no Florida case has ever recognized that change. Therefore, I'm bound by the Florida law. But frankly, I hope that if there's appeal out of this, the state needs to take a cross appeal as to that point. There isn't much conspiracy law in Florida, and it just never has been updated, but it should be. But anyway, based upon current binding precedent, I sustain the objection A, B, and C. Next week.
May I add one quick thing to that? Did Your Honor review United States v. Fields? I already cited that on the earlier motion. Okay. So the A, B, and C would not be offered as
I sustain their objection. Thank you. D and E are on April 19th. Charlie Adelson to Ms. Magbanowa. And then on April 20th, again, Adelson to Magbanowa. Defense wish to be heard on those three calls.
Your Honor, Mr. Garcia, good morning, Your Honor. Mr. Garcia's position is that if the court does entertain these calls, that we would move to sever the cases between Mr. Garcia and Ms. McDaniel, that if Ms. McDaniel was not a co-defendant in this case, this evidence would not be admissible against Mr. Garcia. And obviously, this is something that incorporates culpability within the government's case towards Mr. Garcia. So, with regards to the court's position, that's where Mr. Garcia stands.
Magbanowa.
One brief moment, Your Honor.
And what I'm looking for is some special issue with these. Come on, we're very short on time. Y'all knew this was coming.
As to Mr. Adelson's portion, it would be hearsay. Allows us the ability to be able to cross him as well, too.
I'll overrule that objection. D, E, and F will be admitted. G, Mr. Adelson to Donna Adelson. Say, to have any new argument to make as to that?
It's the same argument, Judge, that it's not being offered as a co-conspirator statement, but rather as evidence of the conspiracy, and that it's not hearsay.
I assume both defendants object to G.
Yes, Your Honor.
Yes, Your Honor.
All right. I sustain the objection, and as to G, it's hearsay. H, any of the defense have any special objection? I understand you're generally objecting to any special objection as to H.
Just renewing my previous objection, Mark.
Same, and add relevance. Your Honor, I feel that the state is trying to bring in certain phone calls to get sound bites, not to try to establish that there was a conspiracy.
Okay. H will be admitted. I and J are Miss Adelson to Charlie Adelson to Donald Adelson, and then back. State have any new argument as to the admission of them?
No, sir.
All right. I assume the defense is objecting to both I and J.
Mr. Garcia, objection.
Yes, Your Honor.
All right. Sustain the objection as to I and J. K, defense have any? K and L, I'm sorry, they're both April 21st. Defense have any special objection as to K and L?
Just what's been previously stated with
Okay.
regards to.
Let's don't look for anything new.
Same here.
All right. Overrule objection to K and L, they'll be admitted. M, Charlie Adelson to Donald Adelson on April 21st, and then Charlie Adelson to Harvey Adelson and Donna Adelson on April 22nd. State have any additional argument as to them?
No, sir.
I assume the defense objects as to M and N.
Correct, Judge. Same objection.
All right. Sustain the objection as to M and N. Then we have a series of O, P, Q, R. Well, let's leave out R and S. Let's see. O, P, and Q. That's Charlie Adelson to Miss Magbanua, then Miss Magbanua back to Charlie Adelson, and then Mr. Garcia to Miss Magbanua. Defense have any special objection as to those steps?
Just a
Conversation O, P, and Q.
Same objection, Judge.
Magbanua.
Same objection, Your Honor.
All right. Overrule that objection. Be admitted. There are two text messages. I have not seen the text messages. Do we have copies of text messages?
Yes, sir. Do you not have the content under?
Is that exactly what, in the content block,
Yes.
is that exactly what's said?
Yes, sir.
Any special objection to R and S?
Actually, no objection, Mr. Garcia.
Same objection.
I'll overrule Magbanua's objection as to R and S. Admit R and S. T and U are conversations between Charlie Adelson and Donna Adelson. State have any new argument as to those?
No, sir.
I assume the defense objects to both.
Yes, Your Honor.
Yes, Your Honor.
T and U, I'll sustain the objection. Then we have on April 26th, call from Miss Magbanua to Charlie Adelson. There is a call from Charlie Adelson to Donna Adelson, then a call from Charlie Adelson to Miss Magbanua, and then a call from Mr. Garcia to Miss Magbanua. Defense have any special objection as to any of those conversations.
Judge, we saw on behalf of Mr. Garcia, we do have a question as to authenticity with regards to call Y, number 128, taken April 26, 2016.
We'll take those up during the course of the proceeding. Any other objection?
No, Judge.
Special objection, Your Honor.
All right. I am going to admit the one call that is Charlie Adelson to Donna Adelson. I assume there's a hearsay objection as to that call.
Which call is this?
W.
Hold on.
You wish to be heard? Yes.
Same objection.
All right. I am going to admit the call between Charlie Adelson and Donna Adelson. I know it's somewhat inconsistent with my prior rulings, but I think that series of phone conversations, there's a showing of a direct connection between them as to the discussion of the phone number. I think that connection is relevant. The statement is not being offered the truth of the matter, but to show the connection. So I'm going to admit V, W, X, and Y on April 26. There's Z on Ms. McBanoa to Charlie Adelson. Defense have any special objection to that?
Same objection from Mr. Garcia, Judge.
Sorry, Your Honor, I'm trying to follow. We're on call 2176.
We're on 2125.
Z.
Same objection.
All right. I'll overrule the objection and admit Z.
Your Honor, I do have one additional, and I apologize.
Okay.
So Ms. Kappelman had shared with us the exclusion of some calls because it talks about potential.
You're talking to him. I can't hear you. I'm sorry.
Yeah, so Ms. Kappelman had agreed to remove out some phone calls because of reference to marijuana or potential marijuana. Before we started today, I let her know that that call references it. That would be an additional objection because I don't believe it's been redacted out. There is conversation about that. It is an uncharged crime.
Conversation about marijuana?
Correct, Your Honor. Picking up a plant.
Say what?
Picking up a plant. There's specific reference to picking up a plant, and I think that any lay person would tie that over to marijuana.
This layperson did not.
And on page 4, Charlie tells you to smoke a fat one.
Actually, joint, a big effing joint.
A big effing, I'm getting this from Code of County Council right now, Your Honor.
Yeah, Judge, it's on page 4, so I'm saying about behalf of Mr. Garcia. Charlie Adelson's, the transcript says, go on vacation, leave the effing kids at home, smoke a big, fat effing joint, and have a cocktail.
That portion has been redacted.
What about the reference to the plant? Where are you getting that?
The plant is still in. I don't.
Where do you see that, Mr. DeCoste?
I just have a quote in my notes. I don't have a page and line reference because we had other things besides reviewing these transcripts to do this weekend.
Page 4, line 7. No. I'm sorry, it's page 4, 7 to 10. Mr. Adelson says, so I was kind of thinking if you want to go away for the weekend, it would be nice to have a gift card and a little tree to plant at your house.
That's been redacted on that copy.
Thank you.
Has that been redacted from the tape?
Yes, sir.
A and B. comments about. Truthfully, it is Donna Adelson to Charlie Adelson and then back the other way. Kind of explains the wrong number that apparently is being used. Shows a connection between the other calls. I'll hear any argument on AA and BB that you want to make specific as to that situation.
Again, Judge, it's not being offered for the truth of the matter asserted. It's actually not true because Charlie has asked Ms. Magbanua to call the number. Ms. Magbanua has indicated to Mr. Adelson that she did call the number, nobody answered, and he's now relaying that to Mrs. Adelson. But no one's actually called the number yet. So it's not that they have the wrong number, it's just that they're lying to each other about having attempted to call it.
Defense. You might?
With regards to AA and BB, given what the government's proffered, what this does is it further confuses the issue with the jury, especially given the fact that Donna Adelson and Charlie Adelson have refused to abide by subpoenas sent by the government in this case. So what we're doing is we're playing snippets of calls between the Adelsons, between the mother and the son and the mother. And while the government's going to come forward and say, well, these are all lies, and people proffered X and people proffered Y, as counsel for Mr. Garcia, as the court knows, our defense is that the Adelsons instilled Mr. Rivera's services for this. Someone from Mr. Rivera's camp came and made a threatening or gave an extortionist type of document to one of the Adelson, and so we don't have the ability to explore the contents of what this call meant, if there was other things that went outside of the call. So in addition to our previous arguments, we would say that this clearly violates our right to confront the witnesses in this call and to clarify issues which are relevant to our defense.
Yes, Your Honor. To add on top of that, Your Honor may see myself and Ms. Kwas feverishly talking back and forth, and what we're discussing at council table is whether we make the motion now under the rule of completeness, because this completely confuses what was going on. I'm not making that argument now, but allowing in just one side of all of these conversations would be very misleading and confusing to this jury, because there's completely different conversations going on that were causing the conversations between Charles Adelson, Catherine Magbanua, and then Catherine Magbanua and Sigfredo.
Magbanua, anybody have any special argument as to that from the defense side?
Judge, I just want to clarify, you are admitting A and B.
A and BB will be admitted.
With regards to CC, we'll stand on our previous objections.
CC, DD, EE, any special objection?
No, Judge, not from Mr. Garcia.
Nothing special, Your Honor.
I'm going to allow CC, DD, and EE. Sustain the objection as to FF and again, I'm a little bit on the fence as to GG. Is a call by Mr. Adelson to the undercover agent. Particular argument the state wants to make on that?
Just that it adds context to the later statements of Ms. Magbanua.
Defense?
This again, Judge, this goes towards our previous argument about our right to confront Mr. Charlie Adelson regarding the contents of this conversation and the previous objections we previously made.
Magbanua?
Would Your Honor mind if I remain seated?
You mind?
Faster.
If you keep your voice up.
Same objection.
No. I'm going to allow GG. Then we have, it just says unanswered. I guess that means there's no conversation, Ms. Kaplan?
That's correct.
All right. And then we have series of conversations between Ms. Magbanua to Mr. Adelson, Ms. Magbanua to Mr. Garcia, Ms. Magbanowa to Mr. Garcia and back and forth between the parties. On April 28th, it'd be HHII, simply a text message, JJ, KK, LL, MN, MM, then NN, which is a text, and OO, which is another phone conversation. Anybody have any special objection from the defense side as to that series of calls?
The only question that I have is, Judge, on the summary that the government gave us on NN, call number 1483, April 28th. I'm sorry, the text. It says, I called 3 times, no answer, and I didn't leave a message, and then in parentheses it says, hang up call at approximately 2:10 on undercover's phone. Obviously, the government's not going to introduce what's in parentheses, correct?
I think I can ask about that.
It's not a document. Is there
No,
a
sir.
document about a hang-up call?
No.
I just was confirming that
Okay.
wasn't.
All right, Magbanowa, anything special as to those?
Nothing special.
All right, I'll overrule the objection. I'll allow HH through OO. PP is on the following day, April 29th, Adelson to Miss Magbanowa. Then there's May 13th, Adelson to Miss Magbanowa, and then from Miss Magbanowa to Charlie Adelson. Defense have any special argument as to those?
Not for Mr. Garcia, Judge.
Your Honor, under the rule of completeness, I would argue that calls 3769, 3939, and 2656, these are calls on.
I don't have any of those before me. We'll take those up when you offer them.
Understood, Your Honor.
Any special argument beyond that?
Nothing special, Your Honor.
All right, so I'm going to allow those calls PP, QQ, RR. The last one, SS, I'm just struggling to see the relevance of the call. You want to explain any relevance of that, Ms.
This is the
Kappelman?
call that's previously been admitted with Ms. Johnson.
The 180 was admitted, Johnson to Charlie. I'm talking about the one above that. SS says Adelson to Magbanowa.
Yes, that's being offered to show that Mr. Adelson was paying for Ms. Magbanowa's Lexus repairs.
Defense.
We object. Once again, with our previous objections, also I believe that there is discussions of marijuana use peppered throughout the call with regards to Ms. Magbanowa. And once again, we believe at this time, after the completion of the court's determination as to what calls are being admitted, we need to sever Mr. Garcia and Ms. Magbanowa.
Ms. Magbanowa objects to relevance. Your Honor, again, I believe that the government is trying to get in certain calls to have sound bites and things to argue. There's no relevance of the things being paid for. Throughout this entire trial during the state's case, they've entered in text messages, other evidence that Charles Adelson was paying for things for Kathy Magbanowa well before their thought conspiracy. This does not add to any conspiracy if they have more evidence of conversations of things being paid for. It's not relevant, Your Honor.
Further, Ms. Kappelman?
No, sir.
I'll sustain the objection to SS. I mean, it's all over the waterfront. There might be some slight probative value, but it causes a whole lot more confusion than it helps. So that would be my ruling on those. Do you need me to repeat those, Ms. Kappelman?
No, sir.
All right. Let's talk about the recording, April 20th, 2016. I've previously ruled that the conversation was admissible, left open the use of the transcript. I've had a chance to go back and again review that. Ms. Kappelman, the defense contention is that your attempt to authenticate that is by Agent Sanford. Is that your understanding?
Yes, sir.
And consistent with Martinez, was he part of the conversation for monitoring the conversation as it occurred?
No, sir.
Well, how do you square with Martinez to admit the transcript and that process?
He was being offered as having some expertise in specialized equipment for listening that would enhance his ability to hear what was being said beyond what the jury could hear.
I'm going to sustain the objection as the transcript. There's no doubt in my mind that a jury listening to this conversation would simply be reading the transcript. They would not be listening to the recording. It is very difficult to follow. I did it multiple times with the aid of headsets. It is very difficult to follow. I don't think a jury would make the effort to follow the recording, which is, as pointed out, is the evidence, not the transcript. So I sustain the objection as the transcript. He would make some argument that he's an expert. I didn't quite follow that, Ms. Kappelman.
Yes, sir. We found some authority, which I can't put my hands on right this second, which indicated that if he had specialized equipment that we could not make available to the jury for listening to the thing, that made it easier for him to hear, that he could testify about what it was he was able to hear with the specialized equipment.
If you have some authority to that effect, I need to see it.
Okay, I'll get it for you, Judge.
All right. At this point, my ruling is it's not admissible. If you show me something new, I'll consider it. It may be I need to have a proffer from Mr. Sanford, but I think that's unlikely.